Welcome to the Hastings Shadmary Show.
I'm Andee Hastings.
And I'm Mallie Shadmary.
Together, we own Hastings Shadmary, an Atlanta-based law firm specializing in family law.
This is a space where we talk all things family law and all topics that touch the area of family law, from divorce to custody to self-growth, personal empowerment, and more. We bring you the truth, from our wolf pack to yours.
Hello, everyone. Welcome to the Hastings Shadmary Show. I'm Andee Hastings, and I have a very special guest with me today. This is Kim Beatty. She has a law firm, Beatty Legal Services, and she is also a family law attorney. She has a specialized practice in juvenile court cases, and we're here to talk about some issues that pertain specifically to juvenile court today. So, Kim, welcome.
Thank you.
So glad that you are here.
I'm so glad I'm here too. I'm so excited.
And just so you know, Mallie is in trial today,
Yes.
slaying, absolutely slaying. So we are manning the fort in her absence.
Yes, I'm honored to be sitting in Mallie's seat.
I'm just so excited. I've been looking forward to this one for a while.
Yes,
so
me too.
Appreciate you joining, and hopefully we can get you to come back sometimes.
I would love to.
So, like I said, Kim is going to talk to us today about not only her passion in family law, but also specifically juvenile court cases. But first, before we do that, we have to ask a very important question.
Oh, I'm nervous. Okay.
So, Kim,
Yes.
are you feeling like a warrior or a diplomat today?
I am feeling like a warrior just because of the things that are going on in all my cases. I have not felt very diplomatic as of late. And I don't know if that's a good or bad thing, but yeah, I think I'm in full warrior mode today.
Well, it's funny. It's interesting, and I don't think it is a good or a bad thing. It is. We talk about this a lot on our show, and the best family law attorneys are a combination of the two, and sometimes we're more one, and sometimes we're more the other.
Yes,
So,
I agree.
I will tell you that I am similarly situated in warrior mode right now. So we are.
I don't know where the moon is situated right now, but I think that that's causing everyone to have to be a little warrior. So
It's true. Well, we had a full pink
Yes.
moon on Friday.
Yes, that's
so we're
right.
still in the zone of the full moon.
Yes.
And anybody who doesn't know, full moons absolutely affect people, their personalities, family law. You always know when there's a full moon or Mercury's in retrograde.
Oh yes,
I've never
definitely.
known more about the movement of the planets.
There has to be an explanation, and I always just defer to that. Like
It's true.
like everyone can't be behaving this way for no reason.
Exactly.
Yes.
Exactly. So I'm with you. Same thing. I'm feeling like a warrior. We've got everybody's acting just a little bit off kilter. We've got some just really precious clients who are going through it. And
You guys have lots of lawyers in trial right now.
yes, we do. We have 3 in trial right at this moment. So it's just 'tis the season, I suppose. So,
Exactly.
well, moving into our subject of the day, thank you for sharing with me. I want to talk about juvenile court cases.
Okay.
And I regard you as an expert
Oh, thank you. That's
in
really
juvenile
sweet.
cases. So, and I really feel like we have a lot of people who have a lot of questions. I think that the juvenile court in particular is kind of an enigma for people. And, there are things that happen there that are so important. And people don't really know how that works. And it's scary because it involves our kids.
Yes.
So I want to just ask you some questions and get the benefit of your expertise
Sure.
for our viewers.
Yeah, and no problem. And I agree that it's an enigma, and it's so nuanced and so different than Superior Court that I think a lot of lawyers especially will go into juvenile court thinking, oh, it's just juvenile court. And they can kind of get ambushed if they don't know some of this stuff. So.
Absolutely. So let's just touch on that for a second. What types of cases belong in Superior Court versus cases that end up in juvenile court? Can you give us some background on that?
Yeah, so I'm actually going to answer that backwards because I think it's easier. So typically, juvenile court has jurisdiction over the three main cases for involving juveniles, and that would be dependency cases, that would be delinquency cases, and that would be what's called CHINS cases, which are children in need of services. And so each of those is their own little beast. The one you're going to think about the most when hearing about juvenile court is the dependency cases. And that is a case where it is alleged by someone that a child has either been abused or neglected and is in need of protection of the court. So that's the biggie. The delinquency cases are quasi-criminal cases. Right. So it's when a child has essentially been charged with a crime and they're not old enough to be prosecuted in superior court. There are instances where the crime's serious enough, they could be charged in superior court. There's some transfer processes that go back and forth with those. And then the child in need of services cases is really unique to juvenile court because that's where you have perhaps a child that's just not obeying the rules at home. And the parent's like, I don't know what else to do with this kid.
Not going to school,
right.
Those sorts of things.
Yeah, so there's truancy, there's runaway is a typical one, and unruly is sort of the catch-all where, like I said, they're not obeying the rules at home. And so a parent, a teacher, a police officer, anyone can petition for a child in need of services. And that's unique to juvenile court because you can look at what's really going on with that child and see, like, what do we need to provide? Is it therapy? Is it something else? Whereas your superior court cases are going to be what you do every day, what I do half of my day. Those are your divorce cases, your modifications, anything involving the custody of the child, which is nuanced in and of itself because we are kind of talking about who has custody of a child in a dependency case.
Right.
But if it's a battle between two parents, that's when you're going to be in superior court. If there's other people involved, such as DFACS, that's when you're going to be in juvenile court.
And what can you tell I think most people know what DFACS is, but we have a tendency because we deal with it every day to talk in our sort of shorthand. What is DFACS?
So DFACS stands for the Department of Family and Children's Services, and each county has their own division. And that's another thing that people kind of think of from TV or movies. I always say, CPS or Child Protective Services. Right. So they are the entity that's going to come in and refer out services for a family or petition the court for custody of a child if the child is being abused or neglected. They are 9 times out of 10 a party to a dependency case.
And dependency cases are cases where children are being abused or neglected.
Exactly.
Okay.
Yeah.
So let's talk about those. What's the procedure? I know you mentioned that, DFACS can petition. Let's talk about these sorts of cases, dependency cases. What are the factors that make a case qualify as a dependency case?
The statute is really specific and defines what is abuse and neglect. So abuse can be physical abuse, it can be mental abuse. Neglect is very broad, and it can include you're not providing for a child's education, you're not providing for a child's medical needs, therapeutic needs. A big one that we see a lot is failure to protect, meaning you may be in an abusive relationship and the child's being exposed to it. So it can range from something as, and I don't want to say small, but in the grand scheme of things, right? It can range from something as the kid's not going to school, the parent's not making them go to school, the child may be having mental health issues and the parent's not caring for that. And it can go all the way up to physical abuse, where we've had the quote-unquote broken baby cases.
Right.
So perhaps, you have an infant with unexplained injuries that has gone to CHOA and had a medical exam and all of that. So it's such a wide range of what can be abuse and neglect. Substance abuse is another thing on the part of a parent or a child that we see frequently in our county. So it's just such a wide range. The definition's broad in the code on purpose, so that way you can bring the petition in juvenile court. Does that answer your question?
It does,
okay.
Beautifully. So just so we're clear, because, I I know that this can happen with people in all kinds of situations that are dependent, like older people. Everything that in a dependency action involves someone who's under the age of 18.
That's right.
Okay.
Yep. So it's always going to be a child, which is defined in the code as under 18.
So you mentioned a situation where if a child is witness to abuse or that sort of thing, because that comes up in our divorce cases sometimes too. How does a dependency action usually come to life in a situation where the child is being exposed to abuse?
Those are some of the hardest cases that you deal with. I think hard on both sides. I think it's hard for DFACS to prove a dependency in those situations because we're not going to victim blame, right? It's more so usually that failure to protect comes in if there's other issues already going on. So, for instance, I have a case right now where there was sexual abuse between two siblings. The parent that had custody knew that the abuser child had issues for a very long time. And even in that parent's divorce decree said, you're not going to ever have this child unsupervised with any of your other children. And he did. And of course, there's allegations that child then abused the other child. So that's more of a clear-cut failure to protect. Usually when I see failure to protect allegations when it comes to physical domestic violence between parents, it's, as I said, there's other stuff going on. Like the one I recall clearest in my head is the parties already had a dependency case with their older children. Mom got pregnant, had a second child. That child was not removed from them because there wasn't present dependency as to that child. And then the parent had a domestic violence incident and the mom got arrested. And so the grounds for dependency there were failure to protect because it was kind of like, hey, we gave you a chance with this one, and you didn't. So it's a really difficult area to prove, like I said, on both sides. And there's a ton of case law out there about that not being the only grounds for dependency sometimes.
An act of domestic violence between parents.
Yeah.
Okay.
Yeah.
Well, that makes sense. I mean, I would think that with these sorts of cases, I mean, they're so fact specific.
Yes.
So how do you, like in a dependency case, what different roles do you have in a case like that?
I like to say that everyone gets an attorney in juvenile court for
Right.
the most part. So that's different than superior court as well.
In civil cases, right?
Yes, in civil cases. So usually we're dealing with folks that can't afford attorneys
Right.
as far as parents, right? That's sort of the typical demographic. Now, I'm not saying that's always true, but as long as you can qualify as a parent, you get a court-appointed attorney. And so I've done parent representation. What I love doing is representing the kids or guardian ad litem work. So do you want me to explain the difference between
that's
that?
what I was just going to ask you.
'Cause
So
I know
that's perfect.
it's probably like, what does that mean? So there's two roles. There's a child advocate attorney, which is just like if you're representing a parent, right? You're advocating for what the child wants. In some cases, that doesn't line up with what is in their best interests. And so that's when a court will also appoint a guardian ad litem. The easiest way I always explain that is, okay, mom's on drugs, child loves mom, wants to stay with mom. So the child advocate attorney has to advocate for what the child wants, but that's not in the child's best interests. So the court's going to appoint a guardian ad litem to say, yes, this is what he wants, but we have to look at the fact that mom's on drugs and there's all these other things going on. Sometimes, and it's usually when there's an infant or, a child that's not of speaking age yet, you can be appointed in a dual role, meaning you can be both the advocate and the guardian ad litem. And that can happen as long as that doesn't conflict, right? So until a child tells you something that you don't think is in their best interest, you can have that dual role.
That makes sense.
And there's also, in almost every case that I work on, what's called a CASA, which is a court-appointed special advocate. And they're volunteers that do a ton of work. The work that CASA does is amazing. They're supervised by, paid employees of the county, but They do the same work as a guardian ad litem, but they're just a regular old person. They're not an attorney. I've seen stay-at-home moms. I've seen retirees. And they will work the cases and investigate the way a guardian ad litem will and make a recommendation to the court. So you're going to walk into a juvenile courtroom and there's going to be 4 to 5 tables filled with people because there's all these players involved.
Right. So does the a CASA, just for everybody watching, do they replace the role of a guardian ad litem?
In most cases, there's not going to be a CASA and an attorney guardian ad litem unless you have that conflict.
Right.
So, yeah.
Gotcha.
So they replace / supplement. And I personally, if I'm a guardian ad litem, I work alongside with the CASA because it's like, why are we going to duplicate work?
Right. Well, and they have typically, people they're doing it, it's a labor of love. And they've got an unbelievable amount of experience.
Yes. And training as well. They're so
amazing.
well trained. Yeah.
So what are the time frames for, what happens in a dependency case? And are there required time frames for things to happen?
Yes, it's very time specific, so similar to a criminal case. There's a lot of statutory timelines. And the reason is because the seriousness of these cases. So just as you said in the beginning, we're talking about people's children, right?
Right.
And so just imagine you're a parent, regardless of what you have going on, someone from the state comes into your house and says, I have a verbal order from the court to take your child, and I'm keeping them for 72 hours until we go to court. So that's the first timeline.
Right.
So if there's been a removal issued by the court for DFACS to intervene and take the child, you have to have what's called a preliminary protective hearing within 72 hours. Those hearings are a very low evidentiary burden, so it's a probable cause hearing, like in criminal. So the lowest standard of proof.
It's just more likely than not.
Yeah, exactly. So depending on what DFACS is alleging, unless the parent comes to you with just absolute evidence contradicting what they're saying, 9 times out of 10 you're losing that hearing. So what people will typically do is waive that initial hearing because you have to have another hearing within 10 days of that. And that is the big one. That's the adjudication hearing. That is an actual evidentiary trial. So you can't have hearsay. You have to have all the proper evidence. You follow the evidentiary rules at that hearing. And it can last, an hour. I've tried a 4-day adjudication. And that is clear and convincing, that standard, burden of proof. So it's a lot higher than that initial hearing.
And why is that?
Because that is it's called an adjudication hearing because it's when we determine whether or not that child meets that dependency standard and where they're going to be. So are they going to remain in the custody of DFACS? Are we going to return them to the parent but under what's called a protective order and say the parent has to do certain things and the court's going to continue to monitor it? Or is the court going to dismiss entirely? So it's a high burden in order to make sure DFACS is doing the right thing and protecting the children. And it's not just how do I phrase this without... It's not just, this family didn't comply with what DFACS was asking of them, so now we're filing a petition.
Gotcha.
And I say that to say DFACS can be involved before anything's filed. So there can be a report made. DFACS can come and start investigating and look at the case and say, we don't need court intervention yet. We're going to call this a family preservation case. So let's see if we give this family certain services, if we can avoid having to go to court. A lot of times we see that in cases with substance abuse. They'll get a parent going to substance abuse treatment. They'll continue to test them, that sort of thing. See if we can kind of steer this without having to do a removal. But, that's what I say, is if you don't have to comply with that. There's no court order that says you have to comply with a family preservation case. So I have seen where a family is like, no, we're not going to work with you, DFACS, because we've heard bad things about you. that it does result in a petition being filed and that whole process happening. So that's why I worded it that way, not trying to throw DFACS under the bus.
No, of course not. Of course not.
But there can be situations where that happens.
So we have the initial 72 hours and then the adjudication hearing. So when I hear adjudication, I think final hearing. But it's not necessarily a final hearing. It's kind of a next steps.
It is a next steps, but it's final in as much as, are we going to have a dependency case or are we not?
Gotcha.
So those are usually the biggest, besides termination of parental rights cases, those are the biggest trials you're going to have in juvenile court, because at all the other hearings, you don't necessarily have to follow the evidentiary rules. Hearsay is allowed in. You can admit documents without them being certified records. For instance, drug screens. Like the department's able to say he failed these 6 drug screens. There's not much you can argue against.
We can't do that in
Superior Court. Right, exactly. And so I would say that's the thing that lawyers get tripped up on the most, is that they come in to say what's the next hearing would be a disposition hearing, meaning what's the case plan going to look like? Say a child is adjudicated dependent at the adjudication hearing. There will usually, if it's been a contested adjudication, meaning we've had a trial and the parent lost, they will do a disposition hearing in 30 days. And that's when the department has to come and say, here's your case plan. This is what we're expecting of you in order to reunify with your child.
So, a quick question, because you mentioned at the beginning that there are dependency, delinquency, and CHINS cases. Are CHINS cases, do they kind of overlap with dependency?
Yeah, I've had to, in the role as guardian ad litem with a CHINS case, had to file dependency petitions on behalf of the child if the parent is really the cause. Usually that's in cases of the truancy of not going to school.
Right.
There's usually more issues going on in the home that as you investigate as the guardian ad litem, you're like, they need more services than we can provide. In a CHINS case, you can only provide services to the child, really.
Right.
I mean, we get family therapy started usually, but I would say that, yes, I have overlapped dependency cases with CHINS cases frequently.
What about delinquency? Do dependency or CHINS cases sometimes turn into delinquency actions?
No, not typically. Typically, that's a child is being a child and has done something stupid.
Right.
Like, it's rare that we see very serious crimes committed by children.
Right.
I'm not saying it doesn't ever happen. But, the ones I recall seeing the most are, like, kids that have, broken into the bathroom at the park and spray painted something, or there's what they call an affray at school, which I think is
the
such
fight.
which is just a fight, but the legal term is an affray.
Right.
And, something like that. Or you have a kid that gets drunk at the football game at school and the cop sees it. So to me, it's like, okay, this is all like teenage behavior.
Right.
But we want to stop it before it gets any worse.
Right.
So that's when you say, okay, this happened. We want to put services in place. And that's usually, delinquency cases are not supposed to be punitive. They're supposed to be rehabilitative. So unless it's something serious, the kids aren't going to the detention center. They get the charge. They have to come to court within 30 days. And then they're also adjudicated. So it's kind of the same process. You can ask for a trial, but it's almost like a baby criminal trial without a jury, but with the judge deciding.
Right.
But there is a representative of the state. There's a prosecutor there. They have to prove their case. That I've not seen any trials in delinquency cases.
Interesting. Okay.
I don't really see delinquency cases overlapping with dependency as much as the CHINS cases do.
I figured that, but
yeah,
I figured we would help everybody watching understand it. So backing up, let's go back to the dependency and CHINS cases. So we talked about DFACS removing a child. Mm-hmm. When they remove a child, where does the child go?
So DFACS is obligated to find a family member if they can. The DFACS actually has to prove at that 72 hours that they've made reasonable efforts to prevent the removal. Now, that's very broad, right? Reasonable efforts. And I've seen them say, for instance, in a case where a child goes to school, they have bruises on them. Teacher notices, makes the report, law enforcement comes and interviews the kid, and they say, my dad beat me with a belt last night. Mm-hmm. In that circumstance, their reasonable efforts can be pretty lax in what I've seen. They can say, well, we couldn't look for a family member because we had to protect the kid from anyone in the family.
I see.
But really, under the law and the statute, is they're supposed to look for relatives, what they call fictive kin. So if you're best friends with your neighbor and the kids go over there and play every day, DFACS is supposed to call that person first. Like, the parent is supposed to be able to give DFACS a list at the time of removal of potential placements. If DFACS deems any of those people aren't appropriate for whatever reason, which again, this is all sort of DFACS operating outside the realm of the court in those 72 hours.
Right.
Then the child will likely go to foster care. And that can be just a temporary foster home. In a really bad situation, if they can't find placement, that child may stay in a hotel with a behavior aid until we get to the 72-hour hearing and see where they need to be placed. So that 72 hours is so difficult on families in all respects.
Right. I can't even,
Yeah.
I mean, in a behavior aid, that's kind of like an official babysitter.
Yeah, that's exactly what it is.
Wow.
So they sit there in the hotel room with the kid and make sure the kid doesn't do anything. They do a great job at making sure that they can do whatever possible before asking the court for that removal. And if they are asking for a removal, like I see, especially in Dawson, I think all of my kids that have been removed from the home have been first placed with a family member, whether it's fictive kin. I consider that family because I think we probably all have aunts and uncles that aren't really our aunts and uncles, but we
Right.
call them that,
Right,
know?
absolutely.
So, I have a very young child that's been placed with an aunt. It's not biologically an aunt, but things like that. So those efforts, they're required to make by law. Sometimes it just doesn't work out that way. Sometimes there's no one else here besides a foster parent.
So what if you have a child in a situation and there are relatives, but they're out of state?
They can't place them out of state until there's what's called, and don't ask me I do know what this stands for, the ICPC process, which takes a long time because basically you're going to work in tandem with another state's agency of DFACS,
right,
or whatever they call it there. And there's like all these statutory requirements that you have to go through between our DFACS and their DFACS. So if you have a relative that's out of state, they're not going to be an immediate placement, but they could be a long-term placement.
So, when we're talking about this situation, I'm sure, like everything involving these cases, placement, you might have to argue on behalf of one of the parties or that sort of thing. I can see how the facts of the case could be so impactful on placement because, it could be that there are people who would otherwise be available, but, let's say it's a physical abuse situation and, we'll say dad is the one being physically abusive and his whole family lives here. Can the facts of the case as to why we got here in the first place affect why, for instance, the child maybe couldn't go stay with dad's family?
Yeah, absolutely. And I've seen that in most physical abuse cases, or especially when there's an unknown explanation. Like both parents are saying, we don't know what happened. And those are those broken baby cases that we're talking about. I've seen them try and place the child with a maternal relative, and then the allegation comes out that they're letting the mom see the child at the house.
Right.
So that's what you're typically going to have
Yes.
concerns with being placed with family members in those kinds of cases. So it's just so fact specific, and there's never going to be the same answer in every single case.
Right. And I would imagine, and I'm asking, whatever role you have, you're kind of going to be performing your own investigation in order to make the arguments to the court.
Yeah, you are doing your own sort of investigation and working on it just like you would if you represented the wife in a case and you needed to know about the estate. Now, the discovery procedures are totally different and limited in juvenile court, so that puts your back up against the wall sometimes. But we get pretty broad orders when we're appointed to represent a child, that you can access school records, you can access medical records and things like that you may need on behalf of the child. And the child's always able to testify.
Which is very different than Superior Court as well.
Exactly.
So child can testify always. Evidentiary rules are different.
They're out the window most of the time.
All of this screams that when you have a case in juvenile court, you need an expert in juvenile court.
Yeah, and I think the difficult thing that we're up against right now in most of the counties is appointed work pays out a lot lower for the attorney than private retained clients. But what I'm finding is that where I feel like I'm really making a difference as a lawyer is in those cases that aren't paying as much and they're, I'm being paid by the county. That sort of keeps me going in our more difficult superior court and domestic cases, is knowing I'm able to, make a difference for a kid or something like that.
Right. Do you have cases where you're, hired by private citizens to participate in juvenile court cases?
Yes. So you can't be hired on behalf of a child. A child is presumed indigent, obviously. Right. However, parents are welcome to hire a private attorney. So when I said at the beginning that, everyone gets an attorney, I guess I phrased that poorly in the fact that everyone has the right to an attorney in juvenile court. And so whether that's as a parent, you want to go hire your own, you want to represent yourself, which happens sometimes too, which is never a good idea in any case. So yes, that is an option.
Yeah. So I want to ask you a question about resources. So we've talked about alcohol treatment, addiction treatment, mental health treatment, that sort of thing. Who pays for all of that?
The county.
Okay.
Yep. So each department's, there's a county level of it and a state level to it, right? And so typically it's the county level department paying for those things, with the caveat that at each and every hearing, DFACS has to continue to prove that they're making those reasonable efforts to eliminate the need for dependency. So they can't just say, we're putting mom in, inpatient rehab when she doesn't have a drug addiction, right?
Sure.
So at each and every hearing, DFACS has to prove to the court that they're making those reasonable efforts. That's a legal finding, but really it goes to the funding.
That makes sense.
Yeah. So it's a fine line to walk, because I've asked for that finding of no reasonable efforts before, and the court's reluctant to do it because of the funding piece of it.
Right. So, kind of, this has been amazing. I feel like we could talk about this all
I
day.
could. I definitely could.
And maybe we just need to come back and talk some more. But, just kind of closing thoughts on this process, and, if somebody finds themselves in it, their family in it, what at kind of a high level can they do? What are the first steps that they can do to help themselves?
So I would say first steps is be realistic about where you are. Do you need the help? And we know we deal with addiction and what we do. We deal with domestic violence and what we do. And getting a person to a place of admitting that they're in that situation and they need help, we can't make them do that.
Right.
So for me to say that's the first step, it's rare that if you're in that sort of scenario, that you're a parent, that you're going to admit to DFACS and say, yes, I need this help. DFACS is not going to come knocking on your door if there's not some sort of problem.
Right.
So you need to be realistic and look at, what is that problem? I've had people call me and say, my child said something at school that they didn't really mean, and now what do I do if DFACS comes? And I tell them, you're honest with them. You're honest with them. Right. They get a rap as the bad guys sometimes, but they can provide good services if you need them. They can do those family preservation cases if you need assistance with things. If you are worried in any respect about any of it, you're worried there's going to be something bad that comes out, try and talk to an attorney. If you're in the position where you can afford an attorney, you're probably in a position where it's a more serious case and there may be a removal. So still continue to be honest with them and get the help that you need.
Well, speaking of that, so if somebody wants to reach out to you specifically about getting help with these sorts of juvenile-involved cases, how would they reach you?
The best way to reach me is email, because I do so much of this. I always like an email so that I can make sure I don't have any conflicts.
Right.
Because a lot of times the court will then reach out to me if something's been filed and be like, do you want this as an appointed case? And I need to be able to look at my emails and say, no, I've talked to that parent. Like, I can't now represent their kid.
Right.
So my email is Kim, K-I-M, at beattylegalservices.com. I am also in the process of getting my social media launched, so I'm really excited about that. So we will be on Instagram. We do have a Facebook page, Beatty Legal Services, right now, if you ever want to reach out through that. But Instagram's coming, TikTok's coming with more great information like this, and hopefully a website soon. It's been in the works for a while. So yeah.
You're juggling a lot of balls. You're helping all these children and these families. When do you have time to do all of that?
Well, yes, that's been like we start a project and we stop it. We start a project and we stop it. So now that's the stuff that we're bringing in help for.
Right,
so.
Right. Well, Kim, thank you so much. This has been amazing. I could sit here with you all day for a variety of reasons.
Same.
But this has just been so informative. I just love talking to you about this subject, and I know that you've helped a lot of people just by taking the time to sit here and talk through it with me.
Well, I hope so. That was why I wanted to be here, not just because I love the wolf pack, which I do. But yeah, hopefully, and if anyone listens and has additional questions, feel free to reach out to me. I have no problem answering that. It is, like I said, and like you said, it's such a universe in and of itself,
right,
where you just need to know what you're doing to deal with it. So.
Truly, because you can stumble through it and bad things can happen before you even know it.
Yes. Well, thank you for having me. Like you said, I could have talked all day about this, so.
We'll be back.
Yes.
Stay tuned. Thank you, everyone, for joining us. I hope that you have enjoyed this as much as I have, that we have being here together. We would love for you to join us on social media. You can find us on Instagram, TikTok, Facebook, and on iHeartRadio, Apple Podcasts, and YouTube. So please tune in, like, and share. We appreciate you spending this time with us, and we'll see you soon. The Hastings Shadmary Show is a production of Hastings Shadmary Family Law and 1066 Productions. It is produced and edited by Ned Hastings.